Hello, and welcome to our next installment of the Established ESOP Forum. The purpose of today's forum is to review the management and treatment of seller debt as it relates to and impacts your ESOP. After the panelists speak today, we will have significant time for Q&A. The goal of the event is to provide high-quality insight so your specific questions are welcome. Even if you feel that your question may only apply to your company, rest assured that there is someone else that will benefit from you asking it. And if you wish to remain anonymous, just leave out specifics that may identify you or your company. You can submit your questions through the chat feature, which the moderator and panelists will be able to see. As a reminder, the format of Zoom webinars does not include video or microphone. This means that other attendees and panelists cannot hear or see you. Questions and comments placed in the chat are encouraged. After the end of the forum today, we will ask you what you thought of the event and how often you think we might want to engage in content like this to benefit your company's ESOP. First today, I want to introduce the experts who will be joining us. We designed this panel to provide a 360-degree view on any ESOP question or topic. So each panelist represents a unique and important perspective from the key aspects of law, valuation, trusteeship, and plan administration. First today is Neil Brosen. Neil is the president of Ventura Trust. He has served as a trustee for many ESOP plans in the past. We also have Coralie Thomas. Coralie is a managing director with HDH Advisors. Coralie's experience focuses on providing a wide variety of valuation and transaction support consulting services. Christy Britch is an attorney in the corporate group at Levenfeld Pearlstein with a focus on ESOPs and general ERISA and executive compensation matters. And John Prudall is the vice president of ESOP consulting at Principal. He has over 30 years of experience in the retirement planning industry and has extensive experience concentrating on clients with employer securities in their plans. Today's topic is what to do with seller debt. Seller debt is a significant component of an overall ESOP transaction. How, when, and why seller debt might be repaid or refinanced are important questions for any ESOP company. With that, I want to start with some questions for our panelists and dive into the details behind the issue and the decision-making process. After our initial conversation, we will finish with questions from our audience. Let's jump right in. And Neil, I'm gonna, looks like you're available now. I know we were struggling a little bit with technology, but I think you're good to go now. So
I am.
Good.
Jeff, can I actually start with a little? Can I just start with a statement before you ask the question?
Absolutely,
I was thinking about
please do.
Great, thank you. I guess the first point I'd like to make is that why do we really care about seller notes? And this may be very basic, but I would tell you I've been doing ESOP trustee work for 19 years, and I've been involved with hundreds of transactions, ESOP purchase transactions, and I've only had one transaction in which there was no seller note involved. So to say that seller debt is involved with every ESOP transaction is pretty close to a correct statement. And I'd like to also note that, seller
debt is appropriate. You literally stole my thunder a little bit, Neil, and that's exactly what I was going to ask you about. So.
Oh, I'm sorry. So why don't you go ahead?
I'm sorry. Did somebody else have a?
Nope. I was going to say, why don't you go ahead?
No, that's perfectly fine. I'm sorry. So. Yep, absolutely. No, you're okay. So Neil, I guess first of all, how does this decision get made? Who decides it? What's the process? What leads up to the company even considering repayment or refinancing of this debt?
Sure. I think that the situation involves the fact that, if you think about it, there's two types of debt involved with every ESOP transaction. There's bank debt, which I'd say typically it's going to be 50% or less of the purchase price, and the seller debt's the balance. On occasion, we have sellers that say, okay, they don't want to deal with bank debt, they don't want to deal with the loan covenants, and they'll actually provide 100% of the financing for the transaction. But typically, if you're looking at the seller debt itself, the subordinated debt, it's an important issue that, the subordinated debt typically is paid interest only during the time that the bank debt's outstanding. And when the bank debt is paid, there is that moment of opportunity where the principal payments on the seller debt can start. But there are also lots of other options in terms of, okay, do you want to refinance to pay off the seller debt? And why would you want to do that? Because typically that bank debt's going to be cheaper. And then the other issue is, okay, if the seller debt is paid, most seller debt has, if the bank debt's paid, most seller debt has warrants attached to it. What happens to the exercise of those warrants? So that's where I would start, Jeff.
Yeah. And those are all excellent issues. And I guess, first of all, who is it that's going to make this decision? Is it the management team? Is it the board of directors? How do you see that play out in a company?
Sure. That kind of question is really the responsibility of the board of directors. It's not the trustee, because the trustee does not get involved with those kind of decisions. And, the management team, to the extent you have senior leaders on the board, they're involved with it. But it's an economic decision that the board of directors would make. And typically, it's going to be the independent directors that would probably take the lead in that regard.
Very good. Thank you. So the board of directors decides that, hey, the financing needs to be restructured in some way. The balance of seller debt and bank debt needs to be examined. What are the options, Neil? And you touched on it briefly, but I guess in more depth, what options does a company have?
Yeah, I think that number one, they could do nothing, which I don't think is a good idea, because like I said, typically the seller debt has a higher interest rate. And the other poor element is the bank loves to lend good companies money. And the bank is typically going to offer rates that are lower than what's on the subordinated debt. So at that point, the board should be looking at what is in the best interest of the company in terms of, future cash flow.
Would the flexibility of repayment of debt factor into that at all? I mean, is there more flexibility? And let's be honest. Sometimes companies get into a cash flow crunch, right? And as you go along, are you going to have more flexibility with one type of debt versus the other? And is that a factor in this decision making?
I would say that I rarely have seen anything on bank debt, senior debt, where their flexibility is involved. But let's make that point. I mean, bank debt's not flexible, except if you have a tremendous relationship with the banker and you had a relationship before you borrowed the money for the ESOP transaction. But I guess I still wouldn't call that flexible. I'd say that the bank may be willing to listen and help out in some situations, but that's not flexible. And from a trustee perspective, I would say that we love seller debt because it is flexible. The documents that the sellers have for their notes have all the provisions that you'd expect in any type of debt instrument. It has provisions for defaults. It has provisions for default interest, but I have never seen a seller note that is perhaps technically in default. I've never seen a seller say, okay, I'm going to, note this as a moment of default and apply my default interest rate. The sellers, want this company to be successful, and they clearly are willing to do things to help ease the burden of that challenge the company's having. And so what we typically see is the seller is willing to do payment moratoriums, restructure their notes in a way to allow the company to get through that hopefully short period of time where they're struggling with their cash flow.
So Christy, you're our resident attorney on the panel here, and what have you seen in this regard? Have companies had to go back to their sellers in the past and try and restructure or make accommodations, for a situation like that?
Luckily, I haven't seen it often. It does happen. There's a couple of times in my career that I have seen this occur. to Neil's point, I mean, Neil said everything that I would say. The seller debt is going to be more flexible. The sellers have a vested interest in this business succeeding. Obviously, if they still have a seller note, they have a vested interest in the business doing well. So I guess nothing Neil said, I would disagree with or add to. I think he did an excellent job covering it. But yes, there is a lot of flexibility in that, as Neil accurately described, that doesn't really exist with the bank. That being said, if the company is having problems paying its seller debt, there's obviously problems paying its senior debt. And I think there's a bigger issue going on there that I think everybody needs to get their arms around. Why is the company not doing well? As we all know, the seller debt is subordinated debt, and that's not going to change. So the bank is number one in line, and they're going to want their money one way or another. So sellers need to be cognizant of that, because if they put up any amount of financing for an ESOP deal and it's not going well, and they're going to, default on senior debt, default on subordinated debt, those seller notes become worthless. And so the sellers are left with nothing. And ultimately that goes to the employees. The employees in the ESOP most likely have nothing. So it's a situation you don't want to run into. And my advice would be, if a company, board of directors, management, if there's some sort of inkling that there's some financial trouble in the horizon, whether it's meeting bank covenants, whether it's the seller debt, whatever it is, I think the sooner you can get ahead of it, have a communication with the bankers, the bank, the attorneys, your ESOP attorney, your trustee. I think kind of getting ahead of it to let everybody know, here's what's happening. Here's how we're thinking we're going to deal with this. Everybody wants to see the company succeed. And I don't think it's a conversation that the board wants to do and call Neil and say, hey, we're in default of our senior debt, and we're in default of the subordinated debt as well. So try to get ahead of it beforehand and see what can be done, because it's not a good place you want to end up.
Thank you. And I don't want to dwell too much on the negative. Obviously, those are the exceptions to the rule, and hopefully nobody runs into that. But as Christy, while we're talking, if a board has decided they do want to restructure the debt in some fashion, especially as it relates to the bank, do they have any legal obligation to discuss this with the seller, or what needs to happen from a procedural standpoint, I guess, to affect the refinancing?
Yeah, so this is an interesting question, and I've seen this done, and I've not seen it done because there was something bad going on. But it was more of just restructuring debt. So keep in mind, if you have bank financing, you have senior debt, and you have seller subordinated debt. That seller debt is always going to be subordinated. However, and I just went through this not too long ago, a few months ago, actually. Seller debt, if the sellers want to pay it off for whatever reason, the company decides they want to get rid of the seller debt and only have bank debt, you can certainly do that. Because it is subordinated debt, you can't just go do that. You need to talk with your bankers. Obviously, with the trustee, and your ESOP attorney should probably get involved, because we're the ones that need to make sure the documentation is accurate, particularly on, depending on how this is going to be negotiated, getting the loan documents up to date. If there's going to be an amended and restated seller note, or a prepayment that wipes it out entirely, you need legal counsel for that. So it is a team effort, Jeff. And obviously they can't do anything if there's bank debt, and they need to talk to the bankers about, this is what we want to do, this is why. If they can justify that they have sufficient cash flow, more than they anticipated, I've seen banks agree to that. One story I have, that the one that I just did, there was two shareholders. They sold to the ESOP a few years ago. They've already had a management succession in line. They were subject to employment agreements for 3 years. And as soon as the employment agreements reached 3 years, the sellers said, our management is competent to take over. We want to officially retire. We want to stay on as independent board members or consultants to the board. But they took out, and their bank debt was paid. They actually took out new bank debt to pay off their seller notes. But as part of that financing with that particular bank, that bank said, we're happy to do this. We're happy to get back involved. You paid off your other debt early, but as part of our subordination, we want you to pay warrants and a note. And I know that's something we talked about that we would discuss at this presentation, but When the seller note gets paid, that's usually a triggering event for warrants to be exercised. And in this particular example that I'm using, they took out bank debt to pay off the seller notes, what was remaining. And then as part of that, the bank still wanted some kind of subordination. And so they requested that the warrants be exercisable at the then fair market value. And we paid those warrants, and I don't remember how many installments we're going to do, but it's going to be annual installments satisfactory to the bank. And they're going to get their warrants paid over time instead of having a seller note paid, warrants exercisable, and then walking away. The bank wanted them to be invested in the business still. And one way to do that was to, we'll let you pay off your seller note, but we want the warrants to be issued in a new note subordinated to us.
Very good.
So as you can see, it's a team effort.
For sure. Yeah, absolutely. And I think that's true in a lot of different ESOP topics, but this one in particular, I think involves everybody. So you're absolutely right. Yeah. Neil, let me ask you, if the company has gone back to the bank now and said, hey, look, we've paid down some or all of the debt we owed you. We'd like to borrow more from you. Are you willing to do so? And the bank says, yes, we'd be happy to do that. And that way you'd be able to take out the seller notes. Does the seller have any control over that at that point, Neil? Or are they just kind of, they take their cash and walk away?
Yeah, I think it's a really interesting point, Jeff. First of all, can everyone hear me? I think I got my computer working.
Yes.
Good, thank you. The short answer is no, they shouldn't have any control. Which is one of the reasons that in any ESOP transaction that we want to have a number of independent directors on the board. Because otherwise, if you look at the board composition, that seller is going to be on the board. Excuse me. One or two other executives will be on the board. And, while they may have obligations as a, board fiduciary, let's be honest, they're still working for the seller. And so it's critical that you have independent directors on the board that can deal with this issue and not have that seller participate in the decisions. I mean, I've had a couple of situations where one that kind of floored me, where the board members were saying, well, gee, the company was so successful that they paid off the bank debt and they were ready to pay, refinance and pay off the seller debt. And someone on the board says, yeah, but he was promised an internal rate of return of X%. And, by paying it off early, it's not going to happen. Well, first of all, that was not correct. But my point is that they were hesitant to take the action that was in the best interest of the company. And so I think it is really, to answer your question more directly, no, the seller doesn't have control of what happens. The board should have control of that decision, and they should be making that decision in the best interest of the company, not the seller.
Okay. And you touched on it, negotiated internal rate of return. How does that really factor into this repayment at all?
I don't think it should. And, again, I would defer to Christy as our legal expert on the panel. My perspective, I don't think it makes a difference.
Christy?
No, yeah, I don't either. And this is maybe a little bit off topic, but the things that Neil has been saying about, who has a say in this, does an interest rate of return to the seller matter? These things go a lot to the board governance issues. And I think when you're dealing with some of these issues, this is an excellent issue, but there's other issues that come up when ESOPs are a few years into being an ESOP, where I think it's always a good refresher for the board, including independent board members, to figure out what is it that our duty is. Because as Neil is saying, you can't have a board that's looking out for the best interest of a seller. Maybe they're conflicting, maybe they're aligned. I don't know, but whatever it is, the board needs to look out for the best interest of the company. And the seller, to Neil's point, doesn't really have a say. But I think the bigger point, this goes to board governance, which I think I find a lot. As ESOPs mature and have these growth life cycles of things, seller debt is always the top of that list. That's when the board needs to really get together and say, what is our duty for this issue? Whatever the issue is, seller debt being the topic of this conversation. But I think that they do need to look at the best interest of the company and not try to parse out, what's the seller going to say if we decide this, is he or she going to be happy or not? So that would be my general.
Yeah, that fiduciary obligation should be first and foremost in a director's mind, I think.
It
and
should be, and it gets cloudy in an ESOP. I think everybody that probably that's listening would agree to that. And it's easy to do, and we all understand and appreciate why it's done. Everybody wants to make everybody happy, but at the end of the day, there are certain fiduciary duties and obligations that Neil has as a shareholder and that the board has as a board. So it's just good to keep those in mind. And I think when you get into issues like this, when you have a board that is dealing with a seller who may or may not still be involved in the business, maybe they're just a board member, maybe they're still involved in day to day, but that can be tricky for board members, and obviously and understandably so. So it's just know your duties and know what your obligations are and to whom. And I think that takes away the what should we be doing and any kind of anybody taking anything personally.
Good points. And that whole issue of corporate governance is another great topic that we'll probably pick up on at some point, and we just don't have time to dive completely into that rabbit hole today. But excellent points. Thank you, Christy. Corley, I want to flip over to you if I could for a minute and ask you, what is the cost of borrowing? How does that impact decisions and of what to do? And once the bank debt is repaid, what should the company be thinking about? How does it affect valuation? How does that come into play?
Sure. Yeah. So I think we've touched on some of these topics already, but once the bank debt's repaid and you're having this decision at the board level, I think you want to understand, okay, if we were to go borrow more bank debt, what is that interest rate, right? Over the last year or two, interest rates have changed pretty dramatically. But what is that interest rate, and how does that compare to our current cost of borrowing, right? So, we've talked a lot about this being a board level decision. If we can go borrow money from a bank at 7% or something along those lines, and we're currently paying a seller loan at 10%, it's probably going to be a prudent decision to go and borrow from that bank at a lower rate, right? In the long run, we're going to really benefit the business there. Now, there's some other topics to be considered. We talk about flexibility of a lender, of a bank relative to a seller, but all things being equal, really trying to push the business towards the lower cost of borrowing in the long run is going to benefit the ESOP. So I think that's the general thought there.
Yeah. And so how would that potentially, does it have any impact on your valuation? If we are able to go back to the bank, borrow perhaps at probably a significantly lower interest rate, but we might trigger warrants in the meantime, how does that all come into play when you go to do your next valuation?
Yeah. On day one, it really shouldn't impact the valuation all that much. The valuation team that the company is working with, they're already factoring in the value of those warrants as if they were going to be triggered. And then when you think about, taking on debt to repay other debt, that's really going to be a wash. So on day one, we really shouldn't see a value change. Where the value change is going to come is over time, right? If you're taking out those warrants, or if you're borrowing at a lower cost of borrowing at a lower interest rate, that's going to have a stacking effect as there's more cash flow, right? Because we have that lower cost of borrowing. So as more cash flow builds, 1 year later, we're going to have more cash sitting on the balance sheet than we would if we hadn't taken any action, right? And that's where we're going to start to see value growth from these decisions.
Okay, good. Thank you. So Christy, coming back, we touched on warrants a little bit, and I guess the question becomes, what rights does the seller have as it relates to those warrants? What rights does the company have as it relates to those warrants?
So if you, that's a good question, because as we all know, they're linked together. Typically, the seller notes get paid, or I'm sorry, the warrants will get paid if the seller notes get paid. And sometimes it's upon full payment of the seller note. Sometimes it's a year after the seller note gets paid. But regardless, the seller note getting paid or refinanced in some way may have an impact on the warrants becoming payable. One of the things I will say about warrants is that, and like, I guess I'll use that example that I was using before. So who would be involved in this? It's not really a seller decision. Again, in the example that I gave earlier, it was the bank's decision. We will lend out money for you to pay off your seller note, but we don't want you to cash out on the warrants yet. We want some stake in the game still. So in terms of the warrants and who has a say in how those are working, it's embedded in the document. It's something, warrant call rights and warrant put rights by the holders in the company they're pre-negotiated. They are part of the ESOP negotiations, and those get embedded in the document. Sellers, however, do have the right to transfer warrants. So, anybody who's listening, keep in mind that although your seller note isn't something you can transfer and gift off to, the warrants you can. So you want to make sure that, and a lot of this stuff is pre-baked into our deals, but when you're doing your ESOP transaction, if there's anybody new listening who's considering it, make sure the warrants have provisions for transferability for gift taxing purposes. I think that those are, and I think Neil can probably attest to this, he probably sees it more than I do, but sellers gifting warrants, for whatever the reason may be, everybody has a personal reason as to why they do things, but I think that's a strong tool. So warrants are very powerful to sellers. Whenever they get the money, whether a bank's saying, we don't want you to pay it off right now, we want you to take it in a note, whether it gets paid off, those warrants are always transferable as long as the warrant document provides that it is. So I think warrants are great tools for a lot of family planning, in addition to the seller's benefit.
Right.
Hey, Jeff, I'd like to add a couple of
Yeah,
points
I was
on
gonna
this.
just ask you that, Neil. Yes.
Sure.
if you've
So
got
the
any
first
other-
point I want to make is that there's always an interesting question when you've got a partial pay down of a seller note. So let's say if you have 500 warrants, just pick an arbitrary number, and if you pay down 50% of the debt, does that mean that the right of the seller have the right to put 50% of the warrants to the company? And generally, I'd say that in the documents that I've seen, we don't let that happen. We don't see that happen. I'm not sure letting that happen is the right answer. We don't see that happen, although I think that there is truly a benefit in doing that. While it may require additional cash outlay or maybe additional note, it does then fix that liability for the future.
That's interesting.
I'm sorry, go ahead, Christy.
I was just going to say that's interesting because we're dealing with this issue right now for one of our clients. They're paying off about half of the seller note. They're using bank financing to do it. And the question was asked, does that trigger any of the warrants? Because it's such a significant amount of the seller note, and the documents Neil was saying it does not specify that. So we're not doing that in this case. But I just wanted to put that out. It's an interesting question. And as we can see, everything, it's like a snowflake. Everything is unique and different for every situation.
Yeah, and the situation I was thinking of when this happened, you're right. The document was not clear, but we did get the seller to agree that he would, we could call, the same percentage of the warrants, and that's helpful. I think the other thing that's worth a note, since we're talking about warrants, is that, almost every document I've seen, it says the warrants can be paid in cash or a note. And the terms of that note are specified. So even if the company doesn't have the cash available at that point in time, it becomes a short-term note that really, again, fixes that liability.
Right.
And the last point I want to make about warrants, and then we'll move on since this conversation is not just about warrants, is that there's a really interesting question about how do you value the warrants. Now, all of us tend to think about it as, well, it's fair market value as determined by the ESOP valuation report. That is the majority of the times we've seen that, but on occasion we've had investment bankers, company financial advisors representing the sellers say, oh, no, forget the ESOP value. We want a true fair market value appraisal, because they know that that's typically going to be a higher valuation than what the ESOP value is going to be. But we've never agreed to that. But it's been interesting to see people try to do that.
That is
Have you seen that, Corley? Or Christy?
I
personally haven't run into that. No.
Yeah, I have not run into that, but I have seen the issue maybe sort of get raised subtly, because some of the warrant documents will say that the warrant price will be determined as a fair market value based on the ESOP appraisal, but then it might have, sometimes it says if it's over 12 months, it won't look at something over 12 months. I've seen sometimes when they say 3 to 6 months, And so the question is, well, okay, if your warrant document says it's the fair market value, so long as it's not over 3 months old, and we're at month 6, then we want to go out and get our own appraisal of the warrant price. So I have seen that discussion.
That makes sense. Sure. So Neil, I just want to kind of rephrase what I thought I heard you say, and tell me if I'm not saying this right. But if we have the opportunity and are able to, gather in some of the warrants as a result of a partial repayment of the seller debt, we may be able to, assuming that the share price is going up year to year, we may be able to lock those warrants in at a lower price than we would if they all came due at the end of the seller notes. Is that a true statement?
Yes, that would, I mean, that makes an assumption that the value will continue to increase,
Right.
which I think simply because of the fact that you've got debt you're paying down, that will happen for some continuing period of time. And I think the likelihood is that, when you look at the valuations and the increase in value of ESOP valuation, it's going to generally increase. And so the company is saving money by paying those warrants earlier if it has that opportunity.
Okay, good.
So Jeff, I also noticed there is a question that got posted. Do you want to deal with that now, or do you want to wait?
I saw that as well. Yeah, go ahead and address it, Neil, if you'd like to address it now. If you want to, let me read it, and then I'll let you take it from there. The question that got raised was, what are the factors to consider when the seller note interest is not higher than the bank rate of interest? In this instance, the company is considering refinancing to pay off the bank, considering refinancing the paid off bank note in order to pay off the seller notes for the seller's benefit. So, thoughts?
Yeah, I think it's a theoretical question that's not real. At least from my experience, I've never seen a seller note that has an interest rate, when you take into account the IRR with the warrants, that's lower. It's a less expensive debt than the bank debt.
Okay, I would agree with you. I don't think I've ever seen seller notes that would have an interest rate that would be running behind the bank notes. Although, the way that interest rates are going up currently, maybe that's something that could happen in the future.
It certainly could happen.
Yeah. So, okay. We haven't talked to John yet today, and I know, John, this is probably not the topic that really leans towards what you do as a TPA, but what advantages, disadvantages do you see in paying off seller notes early? Does it make any difference from your standpoint of administering the plan?
Yeah, no, it does not really impact the administration of the plan. It is more so, like we all talk about, it affects company financials, whether they're going to save cash by making a refinance happen and paying off that seller debt early. But just in my experience, when do I see this? And it's kind of a summary of everything that's been talked about so far. It's really driven typically by the interest rate difference, right? The cheaper interest rate from the bank is the reason to do it. And sometimes I will say that it is also maybe a company's interest to, I'll put it nicely, kind of have the seller out of the business of the company. Things change, and it could be 4 or 5 years after the transactions happened and the seller is still involved in the business, maybe more so than what the rest of the company wants. And so that might be another reason to maybe pay off that seller note, because maybe that seller's involvement in the business their continuing involvement is tied to that seller note. So those are the two main reasons kind of that I see those seller notes get taken out. But as we all talked about, the disadvantages of exchanging a seller note for bank note, while it might be attractive from those two reasons, it is less flexible. And now we had a chance to keep the bank out of the business of the company, and now we're bringing the bank back into the business of the company, and that may not be ultimately desirable. So as I think Corley mentioned, it's not just an interest rate play. It could be also just the flexibility play. And long term, maybe the flexibility is more important to future share price than just the interest rate change. Who knows, right? But that's kind of what I see in, from our clientele.
Okay, good. Thank you, John. Corley, I want to come back to we kind of touched on it already, but I just want to make sure that we're crystal clear on this. If the company takes on more bank debt, is that going to have potentially a negative impact on the valuation of the company, or is that being offset by paying down the seller debt?
Yeah, it should be offset, dollar for dollar. So if you think about, any company going out there, let's say a business borrows $1 million, immediately after that, there's $1 million of cash, right, that's produced. So that debt and that cash are perfectly offsetting each other. And if that cash is then utilized to go and pay down other debt, it still has that reduction, that offsetting reduction. And so the process that we're talking about is really should be value neutral on the day of closing. Okay,
good. I see another comment from the person that sent the question in earlier. So Neil, I'm going to jump back, and he's indicating to us that this wasn't a real scenario. We had a friendly transaction with the seller who was willing to take a lower interest rate, and then shortly after, the bank rate skyrocketed. So I guess even us on the panel, we get to learn something new every once in a while. So real value of doing these forums. Okay, Christy, we touched on it, and I think you mentioned it a little bit, but let's talk a little bit more about transferring warrants. So what would prompt the seller to want to transfer warrants? What's the reason behind that? And is that a typical situation that sellers have that right to do that?
They do have the right, as long as the warrant document provides for it. So I've seen it come up mostly in estate planning for the family. So the seller has children, family members that they want to gift some of these warrants to. Sometimes they feel, I'm getting enough, time to give something back. I gave to my employees, I'm going to give some of these warrants to the family. So I've seen it done after the deal closes. You go through sort of, now we're at ESOP, we're kind of used to getting the quarterly seller note payments. Everybody's like kind of on, autopilot at that point for a little while. And we get the phone call occasionally that, hey, I have these warrants. I would like to gift some of them. And we usually work with estate planning attorneys at that point to get that process documented. But it's, I don't want to say it's nothing complicated, but you do need to see, I would recommend that the seller not only deal with us to get the documentation right from the warrant document perspective, but probably work with their estate planning attorneys. And the other party they might want to work with is their accounting firm, because depending on the value of those warrants, there might be some gift tax issues that come into play there. So it's probably, before they make that decision, maybe just talk to their accounting firm to say, run me some, gift taxing modeling. This is what we think the warrant price is. This is the amount of warrants I want to gift. What does the tax liability look like? So some of that pre-planning stuff is just something that should probably be kept in mind, instead of just saying, hey, Christy, draft me some warrant transfer documents. I'm giving 50 warrants to somebody. Just make sure you do your homework.
And Christy, I don't want to put you on the spot, because I know you're not an estate planning attorney. You're not a tax accountant, but typically, what is that reason for wanting to put warrants into your estate? What are the advantages to doing that?
It's mostly just gift planning, just general estate planning. I mean, it's like any other, I guess I would refer to it as any other asset that somebody wants to gift to somebody. And when the warrants are lower in value, because I think as we understand the warrants, they grow in value as company value grows. Right. And so some of our sellers tend to do that gifting because of taxes more early on in the process than later on in the process, because the tax result of gifting those warrants would be less. the sooner after the, as soon after the, I don't want to say soon after the transaction, but when you're gifting warrants in year 10, I'll just say, that's going to be a different tax ramification than if you were gifting them in year 3 or 4. But it's mostly just to give something to their family through, another gift that they're able to do, but making sure that they're doing it at a time that is sort of in line with everybody's tax appetite.
And Jeff, just to clarify, maybe I misheard you. The seller is doing this to get the warrants out of their estate.
Correct.
And that's what they're trying to do because, again, they typically have plenty of large enough estate, and the warrants will just accelerate that problem. So they're trying to get it out of their estate when the value is incredibly low.
Yeah.
Yeah. Thank you for that clarification. You're exactly right, Neil. I appreciate it. Neil, here's a maybe a somewhat related topic, but a little different. What happens if the company experiences a change of control? What happens with the seller debt? What's going to take place?
Sure, and every loan document and the warrants have the provision, have a change of control provision that essentially would cause that note and the warrants to be callable at that point in time and paid. And the most typical change of control we're talking about is a sale to a third party. That's really the issue. And essentially what you're trying to do, and if I'm the holder of the note and the warrants, I want to make sure that if the company, my former company, gets sold, that I get paid the remaining balance on my note and get the value of my warrants at the time of that sale, because otherwise, theoretically, the documents, my note and warrant document, the term, goes beyond when that sale transaction happens. And, you don't want that outstanding after the sale to a third party.
Okay, good. Thank you. I did have a note here to ask about defaulting on seller notes, but I think we covered that topic early on in the conversation today, so I don't think we need to revisit it. I really want to just ask all the panelists any additional thoughts, any additional ideas or comments that companies should be aware of as they're considering these seller notes.
One thing I will say, and I know our ESOP conferences that we have locally, regionally, and nationally, I know that they're very beneficial. Even for us professionals, we learn a lot by just learning what other people in our industry are doing in addition to the companies going. But keep in mind that what one company is doing that might work for them doesn't necessarily mean that's what you should be doing. And so I really just want everybody to know that, if you're not thinking about these things, or if you did something different than somebody that you're talking to did, it doesn't mean that you're doing anything wrong or that they're doing something wrong. Everybody has a unique situation as to why or why not they're doing something or not doing something. There's really no generally right or wrong answer. And so I can't reiterate enough, it's good to see what other people are doing. Don't get me wrong, but don't hold that to that's what you should be doing. And you have an ESOP team, you have TPA, your sell-side advisors that helped you, your accounting firm, your attorney, your trustee. Really utilize that team and say, I've talked to other people. This is what they did. Do you think this would work for our situation? Or, what do you think we should be doing? We have no clue. And everybody that we talk to does something different. So I just want to, don't feel scared or embarrassed or we don't know what to do, to reach out to your advisors. That's why we are here. And we want to make sure that the company is putting itself in the most optimal position that it can for the long term. We want this ESOP to be sustainable. We want people to be happy and feel that they're getting out of it. And, this is employees too participating. We want the ESOP needs to be, get out of it what we're intending here. And so having these honest discussions, pre-planning discussions, just absorbing the information, I think is one takeaway I would take, because again, the seller debt, and then you have the warrants with it, the estate planning component of that, the tax component of that, there's a lot going on here. And so my takeaway would be learn what you can, ask questions, but know that your ESOP team is there. And that's this is what we're there for.
And Christy, I'll tell you from personal experience, I can't agree with you enough. I know that, back in the situation when I did run an ESOP company, myself and our management team, when we created that ESOP, we didn't know, how to manage an ESOP, how to address all these issues, and leaning on the professionals, I think, was the best thing we could do, because we didn't know, or if we knew, we only knew part of the answer or one of the options. And by talking to the trustees, the attorneys, everybody else involved. So great point. Thank you.
Yeah, I think along those lines, Jeff, I think it's one of the things that we try to do with new ESOP transactions, and sometimes it's typically during the first year. The independent directors that are added, and perhaps even the internal directors that were not sellers, probably are not aware of all of the terms of the transaction. They may not even know the price. They don't know the terms of the bank debt. They don't know the terms of the seller debt or the warrants. And so I think it's really appropriate to have, whether it's the trustee, the company legal advisor, but to sit down with the board and make sure they understand all these elements of the transaction. And that also, I know not our topic, but also includes management incentive plans with SARs, because so often we'll see a management incentive plan that has retention units, but then no one thinks about issuing them, which is really sad, because it gets issued then several years later, and then the value, instead of having a very low basis, the value is much higher, and so the executives don't get the same full benefit. But I think that these are complicated transactions, and along the lines that Christy was saying, don't forget to ask for help. We should all be proactive, I think, in talking to the boards and making sure they understand all of the elements of the transaction, so they can, when issues come up, whether it's prepaying seller debt or things like that, that they understand what's involved and why it was set up in a certain way.
Exactly. Thank you. Anybody else? I'm looking here. I don't think we have any questions that have come in from our audience today. So unless something pops up here in the next minute or so, please, Neil, if you've got another comment.
Yeah, I have one other point I want to make. I mean, when transactions are done, we all are enthusiastic about how the company will perform. Now, we all know projections are what they are. And the vast majority of times we see projections that I would say are aggressive, but aggressive, of course, is a relative term. But the companies don't always perform at that level. And again, the value of the warrants are only work if, in fact, the company is successful. Now, if they're moderately successful, then the value of the warrants will not be as strong. But if the company is underperforming, they may not be worth anything. And we've seen this in sale situations, sale to a third party, within 4 to 5 years after the ESOP transaction, and the company is sold to a third party for a variety of reasons, whether it's the company is unable to continue to service the debt, or other things have happened. And then when you look at, what happens to the warrants in those situations, there's not enough cash flow from the sale. The sale proceeds aren't enough to cover anything for the warrant value, and there may not be value anyway. And it could be that some of the seller debt has to be forgiven in order for the ESOP to get its share from the sale proceeds. So, and I'm not just trying to be a doomsayer, because I truly, as a trustee, support seller debt to the nth degree, love warrants as a way to defer interest payments to a time period where the company has the ability to pay the cash better. But again, it just doesn't always work out as well as one hopes.
Very, very good points. Thank you, Neil. Yes. I did have a comment here from somebody that's just popped up. It says, the company I work for is a new ESOP. Warrants are a bit confusing. Can you recommend any reading material that can help us be less confused? So I have a couple of thoughts on that, and then I'm going to ask the panelists as well. There are two organizations out there that have all kinds of resources. One is the ESOP Association, and the other is the National Center for Employee Ownership. So I would tell you to start by going out to their websites and searching their databases and finding information that they might have on warrants. That can be helpful. I will tell you that I have a book that's kind of my Bible I don't know if you can see it or not, but it's the S Corporation's ESOP book written by the NCEO. And I found this helpful in a lot of respects on all sorts of different topics as it relates to an ESOP. So, getting a hold of some of those types of materials can be helpful as well. Most importantly, and I think we all touched on it just a few minutes ago, that reaching out to the professionals is probably the best thing you can do. And to the person that wrote this question in particular, I will tell you, please don't hesitate to reach out to me. If I don't have, I'm not the expert, but I might not have the exact answer for you. But if I can't get you the answer, I know the folks to get to get you to the right place. So don't hesitate to reach out to me as well, and we'll make sure that we get your questions answered. So anybody else have any thoughts on resources especially as it relates to warrants?
Yeah, I think the two things that you suggested, Jeff, are excellent. I often, and not to pick the NCEO over the ESOP Association by any means, but I do refer my clients when they read about board governance or ESOP financing and what to do. I obviously chat with my clients about it, but if they want to read and just kind of do their own little research on things, I do recommend the NCEO. I think they have great materials. If you look at the website, and it covers so many different topics. So I think for any question you have, this or something else related, I think you can probably find good reading material at NCEO. And a lot of the materials that they have, I know, Jeff, your book was a little on the thicker side there. They have some very small pamphlets that are just as valuable. So I would start there too. And like Jeff said, call him and he can direct you to where you need to be.
Yep, absolutely.
Yeah, the other thing to keep in mind, and I just put a definition from when I Googled it, which is pretty easy, is that warrants are not unique to ESOP transactions. They actually began with non-ESOP transactions and were part of many M&A deals for many years. And then people in the ESOP community, professionals, that involve a corporate finance, began to add them as an element to seller notes, I don't know, 10 years ago or so, more probably, but they're not unique to ESOPs, and the definition of what they are going to be quite the same for an ESOP or a non-ESOP warrant.
Yes, good point. Yeah, they've probably, I'm sure, well over, they go back over 100 years. I'm sure of it. So, and it's a great point. You can find out all kinds of information that way as well. So. Anybody else? Any final thoughts before we sign off for today? Okay. Well, again, I appreciate everybody that's joined us today. Thank you for logging in and listening to our conversation. I hope you found it helpful. We're happy to have the conversation, and if any of us can help in any way, don't hesitate to reach out to us, and we're here as a resource. So again, thank you, and look forward to seeing you at the next forum that we conduct in December. Thank you, everyone.
Thanks,
Thank you.
everybody.